Mr. Monday Ubani joins us now, SAN. He is a new advocate of Nigeria. He's a legal practitioner and policy analyst based here in the FCT. Mr. Monday, we've claimed you for ourselves. But I suspect a part of me is telling me that you might be in Lagos at this point in time. It's good to see you as the NBA prepares for its elections this weekend, and you have written a little article saying that the NBA now needs to take a second look and make sure that they address credibility concerns to avoid another crisis. What precisely are you afraid of? What are your anxieties for this weekend, even as the NBA goes into another election?
Yeah, thank you for having me. Good morning. Well, the point is that over time, starting from 2016, NBA's election has been riddled with crisis in terms of post-litigation after the election itself. And it has given some of the stakeholders a bit of concern because we are the largest professional group in Africa, and we stand for the rule of law and ensuring that things are done properly, especially in the issue of governance. If you know that NBA plays a role in the advisory role, in issue of governance, issue of transparency in government. Now, if that particular body that has such a responsibility has a credibility issue when it comes to electoral process, then we have no right or moral right to criticize what goes on at the federal level or even at the state level at any point in time. And so it has been an issue. From 2018, we have always gone to court after each cycle of election. And stakeholders are saying, what is going on? We should be able to take a look at our process. Is there issue of credibility? And if there are issues, what do we do in order to ensure we have a free and fair election at every time we have election, coming up? So this year's election has also thrown up the issue. And then some stakeholders have queried some of the procedures, that will be adopted in the election. I said, can we get it right? And that is what I understand is the Attorney General of the Federation did. He may have titled it directive. It's not directive. I think it's advisory. The AG does not have any local standing to postpone an election or to call it off. The only right he has as the chief law officer is to put in advisory, which he has done. Can we look at some of the issues that they have raised, as stakeholders, and see what we can do so that we can ensure credibility at the end of the day? So that is presently what's going on. But the INEC met yesterday and agreed that the election must go on and that whatever issues that have been raised will certainly be addressed. That is what actually I understand them to be saying. So we are going on with the election tomorrow.
Mr. Ubani, let's move on to something else. The Appellate Court in Abuja validating the guidelines of the Independent National Electoral Commission, INEC, on the conduct on the 2027 elections, and this case that was instituted by the Youth Party, the case against INEC. So in that lead judgment, we're seeing that the decision of the court was that the YP lacked legal power as local standee to do what it did, and the party did not explain how the guidelines affected it and its members in the conduct of its primary elections for the nomination of candidates for the 2027 poll. So talk to us a bit about this judgment and what this means for the Youth Party going forward.
Yes, I will try to break it down in a very simple language so that even those who are not lawyers will understand what is actually playing out presently with the decision of the Court of Appeal yesterday. What happened is that at the Federal High Court before Justice Omar, the Youth Party came arguing that the amended electoral guideline of INEC contradicted some provisions of the Electoral Act and the Constitution, and for that reason, that guideline should be nullified. Justice Omar looked at their reliefs and looked at what they have brought as facts, concerning the issue of the electoral guideline, and I agree with them, saying, yes, the principle is that at any point in time, electoral guideline remains a subsidiary legislation. And in terms of hierarchy of law, subsidiary legislation cannot override a substantive legislation like Act of National Assembly or the Constitution. He agreed that the power to supervise, manage the electoral process resides with INEC. But in enacting guideline, the guideline must not contradict any provision of the substantive law enacted by the National Assembly. And according to the judge, the learned judge, he found out that some of the provisions of the electoral guideline contradicted certain sections of the Electoral Act. And for that reason, he nullified some portions of the electoral guideline of INEC. And the INEC felt aggrieved, and they approached the Court of Appeal, which in summary yesterday said, one, that it is important we understand that INEC's power to regulate electoral process is derived from the Constitution. If you look at the provision of Section 153, look at the issue of paragraph 15, of the third schedule, part 1 of the third schedule, that it does give INEC power to actually regulate the electoral process, and that what they have done, in enacting electoral process, electoral guideline, is not inconsistent with any provisions of the Electoral Act, and for that reason, the electoral guideline was upheld. But the most important thing that the court decided, which is also very important for Nigerians to know, was the issue of the youth party that came to court. The court was of the opinion that they lack local standard, because in Nigeria today, the present jurisprudence about public interest cases is that for you to initiate and succeed in public interest case in Nigeria, you must show that you have the local, the standard, that you have the standing in order to bring that case. And Nigerian judiciary has adopted a very restrictive approach in interpreting the principle of local standard, starting from Abraham Adesanya's case up to the point where today, presently, in Nigeria, they have adopted that restrictive standing. And what do they usually mean by showing locals? You must show that you have suffered personal injury. Personal interest must be affected or threatened to be affected. And so the court found out that the youth party did not in any way brought before the court any, specific live issue that they conducted primaries and their candidate were rejected, or that they were affected by the timeline to submit the party's register. They didn't bring all that before the court. They only came by way of a speculative, litigation, which is what INEC was saying, that it was purely academic. It was purely speculative. And for being speculative, that the court has no jurisdiction to entertain such a matter that was not a live issue. And so the Court of Appeal agreed with INEC yesterday that one, the youth party has no locus because they were not able to show to the court what injury have they suffered. Were their candidates rejected? Did they conduct a primary that was actually rejected by INEC? And so in the absence of those live issues, then the court was of the opinion that they have no locus, and the court shouldn't have given them any hearing whatsoever at the court below. So that is actually what happened. The court did not go really into the specific of looking at whether those electoral guidelines violated any rights of the political party, because there was none. There was no issue of right that was violated presented before the court below. So the Court of Appeal was of the opinion that in the absence of those injuries being alleged and proven, then the court shouldn't have actually given them a hearing, that it was purely speculative, hypothetical or academic exercise that the court engaged in.
Because this Court of Appeal judgment is setting aside the judgment of the Federal High Court. It does bring to mind the issues that we have where a particular court will rule on something and then you take it to appeal, and then there's no, they say there's nothing here that can make us stand with what you said at this lower court. And then also the case of, bringing a matter to court and not being able to show what your matter is, if your damages are speculative and things like that. So talk to us a bit about the discipline that is required for these sorts of things, and how we can get people to stop, creating these sorts of scenarios, especially in our courts, that we need to do other things.
Yeah, in all this, I want to say that what you have said concerning the consequence, of the judgment, it means that the court have set aside what the lower court has actually given. But the point, look at the procedure. The Court of Appeal did not say that if INEC enacts any guideline that contradicts Electoral Act, that particular guideline will supersede the Electoral Act. No. What the court did not do, the court did not go into the substance of looking at the issue of whether the electoral guideline violates Electoral Act, because there was no injury. The party did not show any injury the electoral guideline has caused to it. So the principle of hierarchy of law is still being upheld by the Court of Appeal. The Court of Appeal is not saying by that decision that if INEC tomorrow wakes up and then probably enact an electoral guideline that contradicts a provision of the Constitution or the Electoral Act, that the court will uphold it. No, the court will not uphold it. Electoral guideline remains a subsidiary legislation. So in terms of hierarchy, the Act of National Assembly is superior. But in this particular instance, the particular party that is alleging that there has been a violation of right did not present any right that was violated. So the court did not go into the specific examination of those electoral guidelines that violate their right, because no right was violated. They did not show evidence of primary election that was rejected, or that they were unable to submit their voters, the members register as a result of the timeline that was given by INEC. So in the absence of the right, being injured in consonance with the jurisprudence of local standard in Nigeria today, the court now held that there was nothing that was wrong with the electoral guideline as INEC itself, because there was no proof of any violation of the Electoral Act. So the position of the law still remains that INEC has the right under the Constitution to enact electoral guideline. We agree with that. But in enacting the electoral guideline, it must not in any way override the provisions of either the Constitution of the Electoral Act. That law is also upheld. But whoever is coming to court over this public interest case must show, one, that he has locus, two, that the court has jurisdiction. So the court was saying that issue of jurisdiction, it was hypothetical. So the court shouldn't have engaged in it, because there was no right that was actually, wrong. There was no right that was actually violated. And in the sense of that, the court was not right to have actually delved into, nullifying the electoral guideline of INEC. That is actually what that decision is all about. If you look at even Justice Omotoshio's case, all of them upheld the supremacy of Act and Constitution over electoral guideline. It remains a subsidiary legislation, and we must all agree with that. And there's no court that will say that electoral, guideline will override the substantive law. No, they will not say that. But in doing this, you must follow the procedural safeguards. You must show that you have suffered a wrong. You must show that you have locus. You must show that the court has jurisdiction. And in this instance, it was a hypothetical issue that that the Youth Party has brought before the court, and not as a result of their rights being wronged or being violated. They didn't show that, and the court said that the court should not engage in such speculative exercise.
Mr. Monday Ubani, we have to thank you, but I'm wondering, do you think that this matter is something that will get up to the Supreme Court? Because we do know that some parties, even though they did not go to court, could have benefited from this. What if they ask to be joined and it goes to the Supreme Court if they have suffered injury as a result of this non-alliance?
It's a very intelligent question. So we are still in a situation where some of us who are public interest lawyers are still insisting that the Nigerian judiciary must adopt a liberal approach with regards to local standards. They must adopt in order to, because governance issues involve corruption and, good governance. Other countries have adopted a liberal, mode. But the legal jurisprudence today in Nigeria with regards to locals is that we are still adopting a restrictive approach. You must show that you have suffered injury, not for the issue of governance. No, that should be done by the person who has suffered injury. That's what they are saying. So if it goes to Supreme Court and the Supreme Court now look at the issue of locals once again and look at it and say we must adopt a liberal standing, fine, it will now be the position of the law. But for now, the Supreme Court, if it wants to maintain its stand, if you don't show that you have suffered injury, don't bother coming to court on public interest litigation. Don't bother, because your interest must be shown to have been threatened or you have suffered injury before you can succeed on public, and that is the present position. So the Supreme Court may be asked to look at it again, sir. Can we look at this position of the local standard that it is very restrictive and it's not helping governance in Nigeria? Can we expand it? That I don't need to show injury, provided that what I'm fighting for is for the interest of the public. You must allow it to stand. So if it does, I hope that the Supreme Court will, because I know the Labour Party, the Youth Party may proceed to Supreme Court over this. The Supreme Court may have opportunity to look at local standard principle once again.
All right, we have to thank you very much, Mr. Monday Ubani, Senior Advocate of Nigeria, for interventions on these matters. And we wish the NBA all the best tomorrow as it goes to the polls.
Thank you very much. Thank you very much. I appreciate it.
That's where we draw the curtains on Sunrise today, this beautiful Friday morning. But I will still wish you a sun-filled day. Thank you so much for watching. I'm Mao Yusuf.
Business Morning is at the top of the hour. I'm Kayla Megwa. Have a great weekend.